you may be expecting Shomon or Ganas to speak on this issue. And if you're surprised with my presence, my apologies. My locus standi, I believe, to speak on this issue is I started working on the issues related to water maybe almost 8 years ago with this issue. And from then onwards, I've been following this issue even now as a sympathizer to those who fight on this issue, as well as from an academic point of view. So that signifies at least one point, that even after all these years, it continues to be relevant. Even the issue is highly contemporary. That means it's not just historical in nature. That means it's a quite older issue, but at the same time, it's a continuing issue. I'm very bad at it. How to operate this? It's okay. I mean, if it's not working, that's fine. See, when I started working on this issue, I also looked at this issue just as a groundwater issue. But after a few years now, I would like to look at it from a larger perspective of intersectoral water conflicts. And Plachimada represents, okay, before starting that, Plachimada is the name of a village in the southernmost state, Kerala, and which happened to be the state where I am also coming from. So, from an intersectoral water conflict point of view, I think I would start with this title of this book on water conflicts, which says "Million Revolts in the Making." So that means Plachimada represents one among many water conflicts in India, and the nature of this water conflict is very diverse. It's starting from intersectoral to intrasectoral, it's interstate, and it also includes international dimensions also. So that means, and the reason why I said Plachimada is one among many conflicts, I just pointed out there are many water conflicts of different nature, and this 3-1 is exactly of the same nature as Plachimada. That is one case again from the same state. I don't know what is wrong with that state, my state, but it is Pepsi case, and this is again the people fought against a Pepsi company from the same state, and the matter went to the court and they failed. And I will come to the reason very briefly down the line. And the second one is Kaladera, which is Rajasthan, which is close, I mean, a few kilometers away from Jaipur. And the third one of similar nature. And in the second and the third one, the company against which people are fighting happen to be again Coca-Cola. That's Mehendiganj in Uttar Pradesh. Okay. So what is so peculiar about the sectoral nature of this conflict is, in many times, which is confrontational in nature between or among the parties on both sides. When I say confrontational, it's not just among the users, and it adopts or it assumes a confrontational nature even between different government departments. And this is something which I realized very recently, that I mean, when you discuss this, so because if you talk to an irrigation department person and he suddenly becomes an advocate or a lawyer of farmers, and when you speak to a drinking water department person, and then he speaks like as if the whole water is meant for drinking water purposes. That means the confrontational nature of this issue is not just limited to users, it also limits to all those implementation agencies, and so far, for good or bad reasons, I don't know how the policymakers feel when they make all this. And that takes us to another point, because the whole legal framework and to some extent the policy framework, which follows, is highly sectoral nature. Despite the fact that we are talking about the same source, and we have a number of instruments, policies and laws which talks only partial aspects of that resource, let it be drinking, irrigation or industrial, and in this case we are talking mostly about industrial usage of groundwater. The reason why I am highlighting this point is to look at this issue from a larger perspective, not just the fact that here is a groundwater and here is a company using it and here is a large village population claiming right over those resources. And the major reason why this conflict happens is from a legal point of view, because the major lacuna is we don't have a proper prioritization provisions in laws in general and in water laws in particular. Instead, what we have is prioritization. Of course, as far as water policies in India is concerned, it's quite clear about water prioritization. For example, most of these water policies, national water policy as well as state water policies, they provide a particular prioritization list and where drinking water comes as the first priority. And in most of the cases, probably this is the only exception I know, that is Maharashtra policy, where in other cases generally irrigation. I mean, the agricultural purpose comes as the second priority, but in Maharashtra it is industry. That's why I cited this thing. And the problem with water policies is that these policies are unenforceable. I mean, this is just a kind of guidance. So long as we do not have such provisions in the law, which is that the life becomes difficult for ordinary citizens, just in case if they want to implement this issue. Okay. To give you a brief account on Plachimada, because this Plachimada portion is generally a water stress area, and the government has declared this area as a drought-prone area. So it's quite often, it's very easy to wonder that how a water-intensive industry could start a water-consuming factory in an area which is water stress A and B, and that area is also an agricultural dominant area. And C, and that area, major inhabitants or the residents of that area belongs to socially and educationally backward class. So it's very easy, but again, the problem is, I mean, there is nothing in the law or in the policy framework to say that which should be or should not be allowed, which in fact became a major bone of contention when this matter came before the court. The Coca-Cola they started their factory in 2000, and the public protest began within 2 years, and the major contentions of the protesting people was depletion of groundwater, pollution of groundwater. The third one is solid waste issue. For most of the outside world, Plachimada is only about groundwater. But the third issue was so critical, which I will come to that point. Okay, it's already there. That means the factory was closed down or ordered to close down by the Kerala Pollution Control Board on this third issue, not on groundwater issue. And the groundwater issue is still pending in the Supreme Court of India after all these years. Okay. This is just to, I mean, give you a picture. I mean, some of those activist people are obviously not professional photographers. They took this photo, or the first one is just picturizing kind of conflict still going on in that part, and the second one is just an evidence to prove that this is a water stress area. And I don't know, maybe whether it was deliberate or not, the guest in that second photo, maybe the dog is also looking or waiting for the water. Maybe it was just a mistake. But however, the issue is the conflict is still going on, and the water scarcity problem, the environmental issues are still there. Okay. Now let's come to this legal aspect of this dispute. I mean, to give you a broad picture on this, like this is a kind of dispute between, for legal purpose, it's a dispute between, on the one side there is a Gram Panchayat, I mean it's a local governing body at the village level, and on the other side there is this Coca-Cola company. And the first party's claim is that they believe or they claim that they can regulate the use of groundwater in their jurisdiction, whereas the company's claim is that since they are the landowners, they can dig out as much water as they want, because they claim that it is their absolute right to dig as much water as they want from their land. But the village councils, the local government's argument is that, see, you can dig, but at the same time, when it affects the larger population, it is our prerogative to step in and control you. And this is the crux of the legal dispute which started in 2003 and now pending before the Supreme Court of India. So it has passed through a number of stages, and first it was argued before the Kerala High Court and before a single judge in 2003, and the single judge gave an order which was in favor of the panchayat, saying that the panchayat has the power to regulate groundwater use extraction by the Coca-Cola company, and the major principle relied on by the Kerala High Court in this case was related to a case which was filed by Mr. Mehta, which is called Kamalnath case in 1997, and this case pronounced public trust doctrine as part of Indian environmental law, and the single judge relied on this doctrine and said that, see, the government is the trustee of the resources, this water resource, so the government has the power to regulate the groundwater use for the benefit of the people. At the same time, Panchayat issued an order to close down the factory, and the government said that, see, Panchayat has no power to ask the factory to close down, but it has the power to ask the company not to extract groundwater. So it means practically if the factory wants to operate, they should bring water from some other sources. I don't know whether that is practically possible for such a huge factory using large amount of water. Anyway, that is their headache. So this is what the first decision from the Kerala High Court. I will focus on the first part, that the Panchayat's power to regulate groundwater. And then the company went to the division bench to appeal, and the decision came in 2005, and the division bench reversed the first decision and gave an order mostly in favor of the Coca-Cola company. And the decision, this is the most important operative part of the judgment, which says that Panchayat had no ownership over such private resources, and in effect, denying the proprietary rights of the occupier is too wide for unqualified acceptance. Ordinarily, a person has a right to draw water in reasonable limits without waiting for a permission from the Panchayat and the government. This alone could be the rule, and the restriction is an exception. So to put it in a very simple way, it says that the landowner has the right to extract groundwater from his or her land, and there can't be any restriction without law, and at that time there was no law to control groundwater restriction. In fact, there was even the legal principles or legal norms to support the company's argument by relying on this common law doctrine, that even borrowing ideas from the Eastman's Act, saying that the landowner has the right over their groundwater. So now this is the fate of Plachimada after a decade, like appeal pending in the Supreme Court for the last 6 years almost. And whenever I discussed with lawyers, particularly these lawyers representing various parties in this case, so the case is over now, and it's not going to be even decided. This is what the signal we get. So that means the issues remains almost dormant at the level of judiciary. And in the meantime, several developments happened as far as this issue is concerned. One, the state of Kerala introduced a new groundwater law, which was introduced or adopted passed in 2002. Then you may be wondering why the law was not applied in a case which was filed in 2003. The problem is, though the act was adopted, passed in 2002, which came into force after the case was filed. So this new law is not relevant for the existing case. But still, this law is very relevant for all future similar issues, if at all it comes. We hope it doesn't come. And another major development is, now that the factory is closed for this hazardous waste issue, and now that the local population is claiming compensation from the company, A, for their personal loss, and B, for environmental damages also. And the government of Kerala responded to this issue by again passing a new law, which is called Plachimada Coca-Cola Victims Relief and Compensation Claims Special Tribunal Bill 2011. And the governor of the state of Kerala passed this law for the assent of President of India, and the bill is still at that stage after 2 years. I mean, this was the last hope, at least from that public movement's point of view, but which is yet to come into force. And there are quite a few allegations that, I mean, the government is being partial or favoring the company, and it is a deliberate thing. But I mean, we don't know the real truth. But again, to bring this law into force, I mean, to take more than 2 years to bring a law into force means that sounds slightly unreasonable. And the fourth major development is, this is why I mentioned the Pepsi case first. I mean, this is the new problem which we are facing in this water conflicts, like strengthening investment regime, because we look at these companies mostly from an investment point of view. And this is what precisely happened in the case of Pepsi case. When the local body filed a case against this Pepsi, the court said that, see, they are working in a special economic zone. And special economic zone is, as per in the eye of law, it is a specially carved out area, and where the panchayat has no power. So whatever happens in that area, you don't have anything to say, you have no say. And this is how the High Court settled the case. That means supposedly we are living in a stage of decentralization. At the same time, all those legal developments are happening or moving in a different way towards more kind of centralization. So the decentralization says that we have to give more powers to the local bodies, but at the same time, from a different angle, we are taking more and more powers from the local bodies. And as far as this kind of conflicts is concerned, here we believed that the local government has a say, because the people usually, I mean, this is the government that responds to such a popular public movement at the first instance. And now that that opportunity is also lost, at least in some of these cases, and probably this Pepsi case is a classic example on that. I think that's it. Any questions? Thank you.